Good afternoon, Jones.
Good afternoon.
When we left off before the break, we were looking at tab 5 of the compendium, which was excerpts from exhibit 1-2018. And if you could go to page 42 of the compendium, you'll find what is called the first agreement of submission. I'll wait for you to get there.
Yes.
And at page 43, you'll see that this is dated Montreal, 10th April 1893.
That's right.
And it's signed by the 3 council for Quebec, the Dominion, and Ontario.
Yes.
And let's just sort of examine what this is about. Now, as I understand it, this first agreement of submission is an attempt by the 3 governments to set forth what it is they want the arbitrators to decide. Is that a fair statement?
Yes.
And in this first agreement of submission, they say in the second paragraph about certain questions have arisen in relation to the settlement of the accounts between the government of the Dominion of Canada, the governments of the province of Ontario and Quebec, both jointly and severally, and also as between the 2 provinces. That's what they say. Do you think that that is a reference to paragraph 142 of the Constitution Act 1867, or was intended that way, or do you not know?
I probably can't say definitively, but the this does include the Dominion of Canada as, I suppose you could say, a party. And I think the intent of 142 was to divide assets and debts between the provinces of Ontario and Quebec.
Okay, so you would say that what's going on now is not a section 142 arbitration. Is that what you mean?
I don't know what there may be another answer to the question. It's just that I pointed out what I pointed out here, that section 142 isn't specifically referenced, and there is this difference, I think.
Yeah, fair enough. The third paragraph, they then repeat the empowering statutes. And we've already been through one of those. And then when they, in the 5th paragraph, it says, now therefore, it is agreed by and between the said several governments, parties hereto, that the following questions, and then they list a series of questions, right?
Yes.
Now, the first question that they ask about is, 1, all questions relating to or incident to the accounts between the Dominion and the provinces of Ontario and Quebec, and to accounts between the 2 provinces of Ontario and Quebec. And item number 2 has a listing, or it expressly says, the accounts are understood to include the following particulars. And item 2F over on page 43 says, all other matters of account, 1, between the Dominion and the 2 provinces, 2, between the Dominion and either of the 2 provinces, and 3, between the 2 provinces. Now, would you agree with me that what the arbitration being contemplated by this agreement of submission is an adjustment of the accounts as between government entities?
Yes, that's right.
And for the very first time that I've been able to see, in paragraph 2D, as in David, we see the phraseology, perhaps unhappily worded, I might argue at some point, but it says the claims made by the Dominion on behalf of Indians and payments made by the government to Indians to form part of the reference. And is it your recollection or understanding that that's sort of the first time we see a reference to on behalf of Indians?
You mean just generally?
No, I mean in the arbitration documents.
You know, I might, if you're including, say, 1870 and all that, I would probably have to go back to confirm that.
Okay, but nothing comes to mind today.
That's fair.
Okay, all right, so I'm sure all the lawyers in the room will be scouring the documents to see for
Right.
themselves.
And I myself am not sure this is the very first reference.
Okay.
I think there may have been, certainly on the Dominion's part, maybe a reference to these claims.
Okay, but you will agree that it's listed under a heading of accounts.
Yes, yes,
And those accounts are as between governments.
yes, that's right.
All right, and so let's go to the 1895 award at page 51 of the compendium. And this is an award of February 13, 1895. And this is the award that ends up going to the Supreme Court of Canada and the Privy Council,
Yes,
where item number 6 about section 109 gets overturned by the Supreme Court, and the Privy Council upholds the determination about section 109. You remember that?
yes, it was 6 and 9 were
6 and
under
9. Okay.
dispute.
So what the arbitrators say, first of all, is in the second paragraph, after they send greetings, they then reference the empowering acts again. You see
Yes.
that? And then in the second paragraph, they talk about have taken upon ourselves the burdens thereof. Would you agree with me that the burdens are fulfilling the obligations under the empowering acts?
Yes,
Thank you. And 2 paragraphs later, about 2/3 of the way down the page, it reads, and whereas certain questions respecting a claim made by the Dominion of Canada against the provinces of Ontario and Quebec in respect of Indian claims arising out of the Robinson treaties. And it goes on to talk about other Dominion claims, but clearly this award is about Dominion claims against the province of Ontario and Quebec.
yes, that's right.
And I note the wording at item number, it looks like there's 2 number 1s, or perhaps one of them is I, or Roman numeral capital I.
Yes, I think that's right.
Not sure why it says that, but what it says is
I1.
in, right, issue
Right.
1.
Right.
Okay. In respect of the claim made by the Dominion of Canada against the province of Ontario and Quebec. And then it says, in reference to the Indian claims arising under the Robinson treaties. Now, is there anything to be made by the words in reference to, as opposed to any other, the verbiage that's used in the agreement of submission? See, the word in reference to doesn't appear in the agreement on submission. I'm just wondering if you can help us with whether there's any difference, or you can trace a reason for the difference.
I can't. I don't know what the origin of that difference is, and I don't think I have any view as to what difference it might make.
Okay.
Yeah.
Paragraph number 1 does, however, of the award talks about in any year since the treaties in question were entered into, the territory thereby ceded produced an amount which would have enabled the government without incurring loss to pay the increased annuities thereby secured to the Indian tribes mentioned therein, then such tribes were entitled to such increase, not exceeding $4 for each individual. Now, for a couple of points here. The issue before them was an increase to the extent of $4 per individual.
Well, again, we're talking about accounts between the two provinces here.
Yes, yes.
Yeah,
fair enough.
they're trying to set a way of calculating what the claim, in this case by the Dominion against Ontario and Quebec, is going to be,
Mhm.
how to do it. So they are, the arbitrators are offering their opinion of what the direction should be to the parties on how to calculate this claim on the accounts.
Right, and the first point that they make is that you should be doing this adjustment annually.
Now, where is that? I'm
Okay,
looking for that.
paragraph 1.
Oh, you mean that it should be year,
Yeah, the calculation should be based on year to each
since
year-
the treaties
years.
were entered into
Yes.
in any year. Yes,
Now, at paragraph 3, the arbitrators write about what should happen about in situations where there's excess revenues in any one year. It should be carried forward to future years.
right.
And they expressly say, but it shouldn't be used to pay for prior years.
Yes.
But what they don't do and they don't mention is about losses being carried forward. I didn't see that anywhere in their decision.
That's true.
Yes. And in the submissions to the arbitrators, I don't recall any either Ontario or Canada, at least up to this point, arguing that such losses should be carried forward. Now, maybe I've missed it, and maybe if you can help the court with this, that would be great, if you can.
You know, I can't at this time recall if there was ever an argument made by any of the parties in the 1894 hearings about carrying losses forward.
But I think everyone agrees, or at least I think the evidence would have it, that when we get to the agreements in 1898 and 1899, losses are being carried forward. Would you agree with that?
Yes.
Did you see in any of your readings in history and based on your expertise, did you see any record of Canada or Ontario saying that the manner of calculation set out in the 1895 award should be ignored? Now, I appreciate they did things differently, but I don't recall a record of any of the parties discussing why the 1895 award or the manner of calculating should be ignored in 1897, 1898, and I'm hoping you can help the court if you recall.
Well, perhaps if we could bring up that 15th award again.
I think you'll find the 15th award at tab 6 of the compendium. Almost like I anticipated your response.
Oh, I mean, I guess it's you're asking whether it was in the third award then, if there were changes. made from
What
the,
I'm trying to get at is if there's anything in the record that discusses why Canada and Ontario chose to do their calculations about revenues and expenses in a way different than what the 1895 arbitrators had recommended or awarded.
I do know, I mean, there is a substantial amount of negotiation that goes on to reach a negotiated settlement that is incorporated into the 15th award. I mean, one could also say that some of the other clauses of the third award aren't exactly the same as the final settlement looks. For
Right. I mean,
example,
it's there,
paragraph number 2.
right. There's no doubt there's differences. I don't dispute that. I'm just wondering if you can help the court with how those differences came into existence, or if there's rationales provided by any government actors that might help the court in deciding what to do about revenues and expenses. That's all. Just looking for some help.
I don't think I can point to anything specific about the, I'm trying to think if there is any specific document that refers to the particular issue that you're discussing.
Right.
As I say, there are differences in the direction from the third award and the final settlement. It's clear from the documentation that there was, for example, a significant amount of work that went on between the accountants for the province of Ontario primarily, and the Dominion. So we don't have a window at this point into all of those discussions that took place.
Right. Now, you mentioned in your answer to me right now about a direction. When you use that word, did you mean the way things went, or did you mean a written direction? What were you referring to when you said the direction was?
In the third award?
No,
Or-
you used in your answer the phrase, or the word, excuse me, direction. And it could be construed that you meant to say some sort of written direction from someone in authority to someone else, or you may have just meant, as I would think you probably did, to say the direction they went was different.
Well, I would say that, we have an unusual amount of insight into the discussions that went on, say, about the number of people to be paid that would be claimed against Ontario and Canada. We do have a fair amount of documentation about that. We don't have as much documentation about exactly how some of the line items that were referred to in the statements were
Yeah.
arrived at.
I apologize, I'm not making myself clear. I'm
Yeah.
going to try and ask a more
Yeah.
direct question. There was no written direction from someone in authority instructing anyone on what to do about the verbiage in the 1895 award. Is that true?
I think as regards your question about the revenues and expenditures and the particular issue of carrying losses, I may just not be recalling it at the moment. I don't know whether I should be too definitive, but I don't recall at this moment if there was any specific direction offered.
That's fine.
Yeah.
That's good enough, because we can all go look at the record. I was just hoping you might be able to help us if you did remember anything, because I haven't been able to find anything, and I've looked pretty hard. But
Right.
it'll end up being an argument, I guess.
What do you mean, Mr. Schachter, when you say what to do about the verbiage? Whether to follow the,
Whether to follow the
Directions.
award, or whether to ignore the award, and if to ignore it, why? I was just looking for anything that might provide illumination of the corporate mind, the government mind, or the mind of government.
Thank you.
Now, what we can say for sure about the difference between 1895 and 1897, 98 is that the Privy Council decision has come down, making Canada responsible to pay the annuities with a claim over under 111, 112.
Yes,
And that's a liability that they initially hadn't contemplated as being a liability they might incur at the time. They thought it was a Section 109 responsibility of Ontario.
I think from what I have seen of the internal correspondence in Canada, the assumption, the first case was that after Confederation, the expenditures on annuities would be captured under Section 109 and would be the sole responsibility of Ontario. But I think they did not completely rule out that it could be a charge on the old province of Canada. There are occasional references to that.
Thank you. Can you turn to page 128 of your report, please? On the second line of your report at page 128, you reference something argued by someone by the name of S.H. Blake. S.H. Blake is, and here we're talking about 1890, around 1895.
Yes,
Now, this S.H. Blake is not the same Blake who was acting for the federal government in 1875 when he did his memo, is it?
that's right. It's not the same person.
Right. So this particular fellow named Blake, is he related to him, or do you know?
I could not find that out. I
Hmm.
was interested in that, but I couldn't confirm that.
Okay. Anyways, it says in your report that he argued that the commitment in respect of the annuity augmentation is based on the honor of the crown or the faith of the crown, not a charge or interest in the land.
Right.
Now, he seems to be arguing that the two are mutually exclusive. Would you agree?
I would cling fairly closely to what Mr. Blake said here, that when he is talking about the honor of the crown or the faith of the crown, I think he is thinking of the promises made at the time of the treaty by someone who was a representative of the imperial government. And he is, I suppose you could say, saying that this is not a charge or an interest on the lands themselves.
Now, when the matter goes to the Supreme Court of Canada, the Supreme Court of Canada, a majority holds that it's not a Section 109 interest. We know that, but one of the judges, Justice Gwynn,
Mhm.
he says it is a Section 109 interest, and he also says that the honor of the crown applies. So Justice Gwynn saw it as the two not being mutually exclusive. You understand that?
Yes.
And I was just wondering if there was anything in, other than Blake's argument, which I think, is there to be read. Are there other writings of Blake or Ontario Council or Government of Ontario, anything you can tell us that might shed light on Blake's understanding or the Ontario's understanding of whether the honor of the crown and Section 109 cannot coexist together? I'm just wondering if there's anything that you could help us with.
Well, I'm thinking of the comment of Sprague in 1869, where he seems to say that Canada has accepted responsibility from the imperial government to pay the annuities, and that the lands went over to the provinces as public lands. And then
But that's a Canadian official.
that's a Canadian official.
I mean, I might be unfairly putting you on the spot. It's not a memory test, but I was just hoping you might be able to find something that I couldn't find.
I'm just looking at Mowat's memorandum of 1870. Excuse me, 1874.
Right.
He also, of course, indicates that the lands were not subject to any trust. And that the policy of the British North America Act relating to Indians was an exclusive federal responsibility.
Yeah, what I'm looking for, Ms. Jones, is very specific. If there's anything in the documentary record where there's a discussion about the honor of the crown on the one side and section 109 interest on the other being mutually exclusive or not. Now, I appreciate that's a legal question, but
Right.
to the extent that the actors historically weighed into the subject, it would be nice to know if you know.
I think there is some discussion in the 1894, the transcripts of November 1894 among council as to this concept of the honor of the crown.
Okay,
But then this is the argument before the Supreme Court. But I think those are the places one might look for a discussion on this
thank
point.
you for that. Can we go back to the compendium tab 2, please? And I just wanted to clear something, make sure that your understanding of history is the same as mine. At paragraph 3 of the Constitution Act 1867, at tab 2, page 6 of the compendium, we have a paragraph entitled Declaration of Union. And it reads, "It shall be lawful for the Queen, by and with the advice of Her Majesty's most honorable Privy Council, comma, to declare by proclamation that, comma, on and after a day therein appointed, comma, not being more than 6 months after the passing of this act, comma, the provinces of Canada, comma, Nova Scotia, comma, and New Brunswick shall form and be one dominion under the name of Canada, semicolon. And on and after that day, those 3 provinces shall form and be one dominion under that name accordingly." That's what the section says. And it's my understanding that the province of Canada didn't, the province of Canada was a party to the Union, and it didn't, and it may have been, as paragraph 6 of the Constitution Act says, severed to form 2 separate provinces from Lower Canada, but it's not like it ceased to exist and a new entity was created. Do you agree with that?
Do you want to just try me on that one more time?
Yeah.
That-
The province of Canada
Yeah.
didn't cease to exist in 1867. It joined Confederation and then Upper and Lower Canada were severed.
I don't know whether I can, and it may not be a question really within my area of expertise.
If it's not, you
Yeah.
can say it's not.
As to whether the province of Canada had any legal life after the 30th of June, 1867.
That question is probably not within your area of expertise about legal life. I'm more interested in, what the people in 1865, 64, 1866, what were they thinking in terms of whether the province of Ontario was going to disappear or was it going to be part of a union? Can you help us with that? Never mind what the law might say.
There was going to be a local government that would cover what we now know as Ontario.
Right.
And then, of course, much of the British North America Act is designed to elucidate what that local government might be responsible for and the assets it would have, for example.
But the people participating in that discussion about union were included people from the province of Canada.
Yes.
And did you see in those discussions any discussion about the province of Canada ceasing to exist?
Well, I think that it was assumed that the province of Canada as an entity would cease to exist and be replaced by this central entity and then a local entity.
And the local entity was made up of the severed units of the old province of Canada, Upper Canada and Lower Canada, Upper Canada, Ontario, Lower Canada, Quebec.
Right.
Correct? Correct?
Yes.
Thank you. Sorry, I just wanted to get the question in before you answered.
It's possible you misspoke, Mr. Schachter, when you said the province of Ontario seeking to exist. You meant the province of Canada.
Did I say the province of Ontario? Well, then I apologize to everyone in the courtroom. I hope you heard it as whether the province of Canada would continue to exist or not.
It was a couple of questions back. Thank you.
Did you understand me to be asking about the existence of the province of Canada?
Yes.
Okay.
When you
If I had said
Stated the
province of
question.
Ontario, you understood we were asking a question about the province of Canada and its continued existence.
yes.
And you understood that I then asked about the province of Canada being severed into into Ontario and Quebec as per Section 6 of the Constitution Act.
Right.
Okay. Perhaps we can, does that clear things up for?
Yes, thank you.
Yeah, my
And
apologies for the
but-
record.
But the answer was, Ms. Jones, you said, I think people thought the province of Canada as an entity would seek to exist, but there would be a central entity and then a local entity. Mr. Schachter put to you, and the local entities would be Upper Canada and Lower Canada.
Right. What we now call Ontario and Quebec.
Right.
Right.
The severed units of the old province of Canada.
Yes.
Thank you.
Thank you. I want to move now to a different topic about the ways in which the Crown saw the RHT and RST annuities related and dependent upon each other. And the place I think to start is Mowatt's 1874 response, which is, I've got a version of it at tab 3 in the compendium at page 17 of the compendium. Now, in 1874, you might recall that Mowat was commenting on the 1873 package he received.
Yes,
And he is of the opinion in his response in 1874 that on the Lake Superior side, there was about $110,060 received before Confederation.
yes,
And then he says, the amount so received in respect of the east and north shores of Lake Huron, the undersigned has not been able to ascertain.
yes,
But with that information, he basically says there's enough that you could augment the annuity already.
yes.
And he's talking about both Huron and Superior. Is that fair?
Well, I think he does look at them separately, but he says that the amount so received in respect of the east and north shores of Lake Huron, the undersigned has not been able to ascertain,
Yeah.
but there is no doubt that enough has been received to entitle as to the increase, the Indians to the increased annuities which they claim, which I would take as referring to Lake Huron, that he thinks that there's no doubt, although we don't know exactly how much, that there is enough to pay increased annuities in the Lake Huron territory.
Okay, so he's in his, when he says the annuities can be increased, he's looking at both Superior and Huron.
He said Lake Superior was 110, which he thinks is enough. And then in Lake Huron, he doesn't know, and he thinks there is going to be a sufficient amount.
Now, his phraseology, he says, but there is no doubt that enough has been received to entitle the Indians to the increased annuities which they claim. Your reading of that is that he's referring to enough has been received on the Huron side. That's what you just told me. And I just want to make sure that that's what you meant.
Yes, I mean, in my reading of it would be that the amount received before Confederation in respect of the lands on the north shore of Lake Superior was about $110,000. So I think he thinks that that's self-evident, that if there's $110,000, that more than $2,000 a year could have been paid out.
Right, but the only data he has to go by is the money received in respect of Lake Superior. Not,
Yes,
he tells us explicitly he hasn't received any information on Lake Huron.
well, that's not quite what he says. He says that he hasn't been able to ascertain the amount so received. But I think that the Department of Crown Lands and just the overall financial position of the province of Ontario might have allowed them to make this statement that if the total amount of money received on Lake Superior was 110,000, I'm thinking that they might have thought, well, on Lake Huron, then, knowing what we know about the provincial finances, that there was no doubt that enough had been received.
Another hypothesis of what he meant. Sorry, maybe before I put my hypothesis to you. What you've just told us is your I don't, should I call it a guess? It's what you're surmising might be reasonable, but you're not able to definitively say that that's the case.
That's correct. I mean, we do know that in the Lake Huron territory, there were significant dispositions of land and timber. So
Okay.
the government of Ontario would have been privy to that information as well, just in a broad sense, even if they didn't have a particular number in mind.
Right. Another thing, another way that Moet could have been looking at it, and again, we can't verify this one way or another, I hope you would agree, is that the 110,000 was enough to satisfy the increase for both Huron and Superior. So that's all that we needed to know about. That's all he needed to know about. Isn't that another possibility?
I'm not quite as convinced of that, that they would have, given that there were two treaties, said that the revenue from the one could be included in calculating the entitlement for the other. To me, that's a little bit of a bigger step.
Well, I think you're going to go with me on that step at page 76 of your
Okay.
report. Let's see if we can't break that down. Because the next thing that happens is that Commissioner of Crown Lands, Pardee, produces an estimate of revenues from mining locations, timber and sales of lands included in the Robinson Superior Treaty of 110,000 before Confederation and $272,000 after. Pardee observed that a similar treaty had been signed covering the north shore of Lake Huron, but that the northern boundary had not been clearly specified in that treaty, and that the Indian Department at Ottawa would need to provide more particulars of this boundary before an estimate of revenue could be developed. And it's with that information about Lake Superior revenues that Ontario went ahead with the plan to have Canada act as paymaster in 1875 for the $4 for both treaties. We'd agree with that.
Yes, understanding that for much of the territory included in the Lake Huron Treaty, I don't think there would have been any dispute. In other words, around the shorelines of Lake Huron, where the reserves were located, for example, it's clearly within the treaty. It happens to be the place where most of the land dispositions that have been made were made. The area that Pardee is uncertain about is the area to the north and I think to the east. So, you know, it's not as if they're operating in a complete vacuum here about where the Robinson-Huron Treaty territories might be located. There's really only one part of the boundary about which there is some uncertainty. And then Pardee is saying, until we know that, I can't give you as clear a set of numbers as I can for the Robinson Superior Treaty.
Well, you know, he's not saying a clearer set of numbers. He gives no numbers.
Yes.
Right, that's a difference. In any event, with the numbers that they had on the Superior side and whatever they may or may not have known about the Huron side, a decision is made to go ahead and pay both Huron and Superior $4.
Yes.
Okay. And would you agree with me that for a period of time from about 1859 to 1874, the Batchewana band, which is an RHT band, was paid its share out of the annuity, out of the RST annuity entitlement?
I would have to go back to confirm that in those years. That's when the Hudson's Bay Company was making the payments in Superior.
Perhaps if we go to tab 7, which is part of Eric Angel's report. Eric Angel testified for the province of Ontario, and he had a nice chart where he tried to explain it. It was a table D2 entitled Robinson Superior Treaty-Wide Annuity Account, Summary of Account Activity 1851 to 1909. And I was hoping this might help refresh your memory because I have a question about it after I establish that you agree that, I hope you're going to agree that Batchewana ended up getting paid out of RST funds. And if you look at the first reference under revenue, and by footnote one, it's 1,898.50 with footnote 145. And the footnote 145 says this lower amount of 1,898 occurred because the annuity amount payable to the Batchewana band was credited directly to that band's account starting in May 1866. And then if you look at it, distributions, you have to go over to the second page. It's page 62 of the compendium. Under distributions, it says 1,898 and $101.50. If you add those two up, it's $2,000.
Right.
101.50 begin in 1859 and continue in 1865. And in 1866 and 67, there's a single distribution of 1,898.50. So we're short each year $101.50. And that if you look at footnote 150, you'll see that what's happening is that when there's a capitalization, part of the capitalization actually goes over to benefit Batchewana.
Yes, thank you.
Ms. Jones has already indicated she would confirm for herself the proposition that Mr. Schechter put to her about the Batchewana ban. I don't think directing her to conclusions from Mr. Early's report will assist her.
Why don't we let the witness answer? She might say exactly that, or she might have another view.
I might say exactly that. You know, I have not, obviously, this is not my work here, so
Right.
I have some difficulty in.
All right, well, we
in
can deal with
testifying to
it. We can deal with it this way. I'd like you to take a hypothetical.
Dear.
And the hypothetical is that from 1859 to 1874, the Batchewana band was paid out of the superior amount of 2,000 per year. Just go with me on that. It's a hypothetical. My question to you about that is, did you see anything in the historical record that might explain why Batchewana is being paid
Separately.
out of the superior funds?
Why they're being paid out of the.
In my hypothetical, they are being paid, and I'm asking if you saw anything in the record that would help explain why they were being paid.
Actually, Your Honor, Mr. Authority, she doesn't know, so asking her to say, can you explain why? You're gonna have to-
Okay.
It's a bit unhelpful.
I think the question wasn't to explain why. The question was, did she see anything in the historical record?
To support the hypothetical.
Right. Did she see anything in the historical record?
Right, but she had said she would have to confirm that whether or not
Could-
that's occurred
yeah.
at all.
I'm going to ask you not to lead the witness too much more in your objections.
My apologies, Your Honor, those were Ms. Jones' words that she would have to confirm for herself.
Thank you.
I mean, this was not a part of my research for this report, so I really don't know how much more I can say about it.
If you can't help the court, that's fine. I wouldn't be asking that particular question if I knew the answer myself and it was in the record,
Okay.
right? Or if I could find it in the record. So you can't help us. It's not within your report, and we can leave it at that.
I think that's a good place to leave it.
Okay. Can we turn to slide 101, please? This is your demonstrative, slide 101. You might recall that in direct testimony, you talked about the feeling after doing some of the work and looking at some of the data amongst Ontario and Canada that there would in all likelihood not be a surplus on the Superior side for some years,
Yes,
not never, but for some years.
yes,
And at that time, and here we are in 1899, there's no opinion and no conclusion that the RST territory will never produce a surplus, only that it might be for some years before it does.
right. So that's the opinion of Mr. Scott, the chief accountant, January 1899.
And then if we go to slide 106, we have McLean to Hogg, again, saying that the deficit position, at least based on the data that they looked at, would continue for many years to come.
This is a letter from Hogg to McLean.
My apologies,
Right.
thank you.
For many years to come, yes. So
So-
this is May 1899. This is Ontario Council to the Department of Indian Affairs.
Right, so both sides are talking about, for some years to come. And if we go to slide 111,
Was that were you asking the witness to agree with that proposition? So both sides were talking about.
yeah,
for some
yes,
years to come?
yes. That's what was happening, correct?
I believe that Canada Council is, he's basing this opinion on both the statements of 1898 and possibly on Scott's memoranda and opinions. So he's repeating them back to the Department of Indian Affairs.
Then when we get to slide 111, we have Hogg now opining that no, and this is June 28th, 1899, and it's also tracked in your report at page 158 of your report. He opines that no question will arise for the future. He's talking about the Lake Superior side, and no hope of any amount being available for the purpose of a payment of increased annuity. That's what he says.
Now we've lost the screen here, so I'm
Oh.
going to go to my,
Okay,
Paper
it's
copy.
slide 111 or page 156 of your report.
yes. And again, this is Ontario Council. Or Canada Council, sorry. Council for Canada, who is briefing the Minister of Finance.
I'm sorry, so who's the author of this? It's not Hogg then.
Yes, it is. That's Council for Canada. And he's briefing the Minister of Finance.
Okay, and
Sorry,
I'm,
could you remind me who Scott is?
He's the accountant for the Department of Indian Affairs.
Got it. So Dominion to Dominion, Dominion to Dominion.
Yes, this
Thank
is
you.
all internal to the Dominion then.
right.
Thank you.
But now the Dominion, Mr. Hogg, is being a little bit more definitive and saying it's no longer for some time in the future. It's now, it'll never happen kind of
Right.
attitude.
Right.
Now, did you see anything in the correspondence that would, other than the data, reinterpreting the data, anyone can do that. But is there anything else that caused him to change his mind from it'll be some time to, it'll never happen kind of attitude?
No, I didn't see anything that would be additional to what's already before us here.
So we don't know what he was relying on to provide that opinion.
As far as I know, it was just the statements he had that had been agreed on and Scott's memoranda, as well as some, he had been in correspondence with some of the other parties, but I don't think they were talking about the length of time for capitalization for Superior, whether it would be forever or just for a number of years.
Okay. Now, at page 160 of your report, you observe that Hogg understood that the decision on what the future may hold would be a decision for cabinet. Is that a fair summary of what you're saying? Or what you opined in your report?
Are you referring specifically to the letter to Irving?
I believe we're talking about the letter to Irving, but the issue is Hogg tells Irving, look, I can't commit to anything until the minister makes a decision.
Yes.
Thank you. And so it's the minister's decision about what to do about the arbitrations, not Hogg's decision.
Yes, I should clarify at this point, he's gone through the Minister of Finance. So he has some feedback from the Minister of Finance, which he thought the capitalization issue would involve them directly. He has also been informing the Department of Indian Affairs as to what is happening. What he's talking about in the letter of the 25th of August is that, of course, if there's going to be an order in council, that has to be submitted to cabinet.
Right. He's
Right.
saying that cabinet has the final say.
Yes.
And it goes to cabinet, and let's take a look at the cabinet or the report of cabinet. And I think we can find that at tab 6 of the compendium. I think it's may also be referred to at page 161 of your report. Let me just make sure.
Yes, that's right.
Yes. So it's at page 56 of the compendium. And what cabinet or the Privy Council approved by His Excellency on 8th December 1899 includes in the third paragraph that under the said treaties, the said Indians ceded certain lands to the government of the province of Canada in consideration of a cash payment, and the further payment of fixed annuities of $2,000 per annum in respect of the Superior Indians and $2,400 per annum in respect of the Huron Indians, which sums were to be increased under certain circumstances and conditions set out in the treaties, to an amount not to exceed $4 for each Indian. And so clearly you would agree with me that at least at this time in 1899, what cabinet is thinking in their minds is that the annuity augmentation accounting with Ontario is in respect of an amount not to exceed $4 for each Indian. Would you agree with that?
You've heard the evidence that I've submitted about the decision to claim a certain amount against the provinces of Ontario and Quebec through the arbitration process.
Right.
And that was not even, of course, the amount that would have reached $4 for each Indian. So I think it's important to read that particular paragraph in the order in council in that context.
Okay, would you agree with me that, sorry, can you go over to the next page, page 57 of the compendium? After the order in council is recorded, there's Boyd, Cassote, and Burbridge's names underneath the OICs.
Yes,
And why would that be?
that's because when these orders in council were incorporated into an award, which is the 15th award, each of the arbitrators signed the orders and the order in council, just to, I think, signify that they had received the order in council and as in their official role as arbitrators. And again, if you look at the original, you can see that they've each signed it.
Right, but the point is that these orders in council, both of, each of Ontario, Canada, and Quebec form part of the award.
Yes.
Thank you. Can we go to your slides 15? And I'm almost done. Famous last words. I hope famous last words.
Did you
Slide-
say, I'm sorry, 115,
No, 15.
15, thank you.
At slide 15, you quoted from the 1837 United Kingdom House of Commons Committee report on Aborigines of the British settlements.
Yes.
And the portion quoted at slide 15 makes the point that the protection of the Aborigines should not be left to the local legislature.
Yes.
And the reason given is that the local legislature has an interest in the outcome and is therefore a party to any controversy and should not be the judge in such controversies. That's the reason given.
Right.
Now, I like to say that this is just a version of the cautionary tale of the fox in charge of the chicken coop. You've heard of that expression before?
Yes.
Is that a fair summary of what's going on?
Well, to say that in areas where settlers are in the majority in local legislatures, that the interests of Indigenous people should not then be entrusted. This is in the view of this House of Commons committee, which I think was influential for many years afterwards.
Now, would you agree with me that the impression left by that report, or the impression intended to be left, or the takeaway intended to be left, was that it would be better for the imperial government to be in charge of Aboriginal affairs because they, the imperial government, are somehow above the fray and not a party to the dispute and could be more objective towards the Aborigines?
Yes, I think that's a fair characterization.
Thank you. Would you also agree, however, that to the extent that the imperial government had a pecuniary interest in reducing their expenses of Indian affairs, they too would have what's called skin in the game, and they too would be considered like a party?
Well, I think what we see over time is between, say, 1835 and 1860 is the withdrawal of the imperial government from its role in managing the affairs of the Aborigines, as they call them there, and transferring these responsibilities to what they would call local governments.
Would you agree with me that what the imperial government did in 1860 in giving complete control to the colony was inconsistent with their rationale in the 1837 committee report?
Yes. So this is the period of time that has elapsed, and all of the events that have happened in between have affected this, the implementation of this idea, which, you know, I should say too, the committee, of course, was a group of people who were interested in the indigenous people of the British Empire and in their rights and in how these people should be treated. And one could look at their recommendations, for example, besides this one, and say that in the modern era, we would consider some of their recommendations to be inconsistent with protecting the rights of indigenous people. But this particular quotation from that committee of interested people, as I say, I think had some influence long past 1837.
Would you agree with me, Ms. Jones, that under anyone's interpretation of the 1850 Robinson treaties, someone after 1850 had to keep track of revenues and expenses within the treaty territory in order to know if an augmentation was due?
Yes.
Okay. All right, that's fair. I'll work with it as a hypothetical. I'd like you to assume that under any person's interpretation of the 1850 Robinson Treaty, someone had to keep track of revenues and expenses in the treaty territory in order to know whether it's time to augment the annuity. I'd like you to assume that. Can you tell us if the imperial government did anything between 1850 and 1860 to help keep track of revenues and expenses?
There was an inquiry from Mr. Pennefather, who was an imperial official, to the Department of Crown Lands in 1857, asking for such an account or an opinion on whether the augmentation clause might be triggered. That's the instance that I can think of between 1850 and 1860.
And that response from Pennefather to the Crown Lands Department resulted in a not data being provided, but no, and I'm paraphrasing, no, there hasn't been enough revenue generated yet.
Yes.
Now, aside from that one inquiry in 1857, are you aware of any attempt by the Imperial Crown to put in place any measures to track revenues and expenses?
I would say the Imperial Crown did not do that directly. That's correct.
Well, would you say that the Imperial Crown did it indirectly? Did they put anything in place?
No.
Thank you. Are you aware whether the province of Canada between 1850 and 1867 put in place methods to record revenues and expenses to be used for augmentation?
There were certainly records of revenues and expenses in the treaty territories that would have formed part of the normal accounting of the
Right.
finances of the province of Canada.
Was there any tracking being kept specific to the Robinson Superior Treaty to ascertain whether an augmentation was due in respect of the Robin Superior Treaty annuitants?
Well, as I say, there was the regular record keeping of the Department of Crown Lands and the other departments.
And that was province-wide. It wasn't recorded on a treaty-wide basis or treaty territory basis.
Well, each source of revenue would have been entered. What we see in some of the reports of the Department of Crown Lands are aggregated data. But there would have been, say, records from each Crown Land agent, including, say, the ones at Sault Ste. Marie.
You would agree with me, Ms. Jones, that there is not one record of someone, some Crown official, be it Imperial or Province of Canada, writing to the effect of, let's keep track of the revenues and expenses specific to the Robinson Superior Treaty Territory, so that we can know whether and when to augment the treaty, the annuity. Would you agree with that?
Yes,
Okay, thank you. If you can go to your report at page 113. You tell the story of Van Kunent in 1893, writing to Newcomb about increases beyond $4 per capita.
right.
And you also report that Newcomb replied that the point to which you refer to will not be lost sight of. And of course, the point being increases above that based on $4 per capita, correct?
Above $4, yes.
Yes. And we know from the facts of the history that any increase beyond that based on $4 per capita was indeed lost sight of and never pursued by the Crown. Is that correct?
I don't know whether I could say lost sight of. What Newcomb is saying here is that he thinks it is very questionable whether that provision could be made the basis of any legal claim.
Against the province of Canada.
Yes,
And you made that point indirect. My point is, I'm not aware in the historical record of Canada, Ontario, the Imperial Crown taking up Newcomb's suggestion to inquire whether the annuity might be increased beyond that based on $4 per capita. Are you?
now, could you give me that question again?
I'll try. I'm not aware of the Imperial government, the province of Ontario, or the government of Canada, the Dominion, at any time taking up Van Kunent's suggestion to look to see whether the augmentation of the annuities in the Robinson and Huron treaties could be increased beyond that based on $4 per capita.
To be increased beyond $4 per capita?
Beyond that based on $4 per capita.
I guess I'm a little confused by that wording. Beyond that,
Okay,
based on $4 per capita?
aside from the increase to $4 per capita, there have been no further increases.
That's right.
And neither the Imperial Crown nor the Government of Canada nor the Province of Ontario ever turned their mind to Van Kunent's suggestion about looking at increases beyond $4 per capita. Is that correct?
In this time period, I mean, we can say that there were all these statements exchanged, which may or may not have indicated that an increase greater than that could have been paid. Um, the question would be whether Canada would make that a claim against
No.
the old province.
I'm not asking about claims against the old province. I'm asking if there's anything in the historical record where any crown entity turned their mind in any way to answering the question, should we increase the annuities beyond that based on $4 per capita? I think the answer is no. I'm hoping you agree with me.
Well, I mean, again, there were all these statements exchanged. There were a few references to an increase beyond $4, but Canada appears to have made a decision not to claim against the province of Canada or its successors for that amount of money.
Again, that's not my question. My question isn't about what they claimed against Ontario. My question is, in your review of the historical record, how far did you go? Did you go to 1900 only? Or did you go to 1970?
Oh, no, I went to about 1908.
All right,
But a
up
few
to
documents
1908, you cannot show me one document where Canada turned its mind to increasing the annuity greater than $4 per capita. Can you?
Well, I believe I quoted, a part of the transcript from the arbitrations where that possibility was raised. In the arbitrations, Canada made a choice. It was already paying more than it was going to claim against Ontario and Quebec. And it appears to state that if it chose to pay more than $4, that would be the responsibility of Canada. That there was an exchange with Solicitor General Curran to that effect.
There is no record in the documents you have reviewed whereby Canada adverts to, turns its mind to increases beyond $4 for the Robinson Superior or Robinson Huron Treaty beneficiaries. Is that true?
Well, again, it depends what you make of this extract from the transcript and some other comments by Ontario to the effect that Canada has given up or will, essentially be able to pay the Robinson Treaty beneficiaries whatever it likes after it has signed this or has come to this agreement with Ontario that they reach, that's encapsulated in the 15th award. So I don't know whether we can say that it's completely discarded here.
Caitlin? Thank you very much for your time. I think there's going to be someone else with a few questions for you, and then you'll be done.
Before I get started, I do note the time. We have been going for a while. As indicated, I do believe I only have about 15 minutes of cross-examination, but I'm in the court's hands as to whether we should take a short break now. I also don't know if any re-examination is anticipated.
We're gonna go.
All right, sounds good. Good afternoon, Dr. Jones.
Hello.
My name is Spencer Bass. I'm counsel for a group of 7 of the plaintiff First Nations in this case. And I only have a few questions for you this afternoon. And my first question regards when you discussed the 1870 arbitration, you noted that neither Ontario nor Quebec at the time seemed to have raised the possibility of an increase in the annuities.
That's correct.
And I actually want to take you to page 59 of your report. I'll give you a second to get there. Are you there at page 59?
Yes,
Okay. And in that first paragraph on the page, you're discussing the 1870 arbitrations, correct?
yes,
And you note about 5 lines down in the paragraph, the sentence starts the last prior. Do you see
yes,
that? And you write the last prior and possibly only investigation into whether the revenues of the treaty territories might be sufficient to trigger an increase in the annuities had taken place in 1857 in the context of a special inquiry into Indian affairs in the province of Canada undertaken by Superintendent General of Indian Affairs, Richard Pennyfather, Froom Talford, and Thomas Worthington. Do you see that?
yes,
And that's referring to the Pennyfather report.
yes.
And so you didn't see any evidence that the Crown had undertaken any analysis of whether the augmentation clause had been triggered between 1857 and 1873?
That's correct.
And did you want to specify crowns when you asked that question or no?
I was using the question more broadly. I imagine we can break it down. The Crown would include at that point both the province of Canada, the province of Ontario, and the Dominion government. Would your answer change if I break it down into those entities of the Crown?
No, we know that there have been representations made by Canada to Ontario, but I don't have any records about a particular inquiry by Ontario made at that time, which may in part just reflect the fact that there are many fewer records from the province of Ontario at that period than there are from the federal government.
And you didn't see any records from the federal government either of it undertaking this inquiry prior to 1873?
Well, in that the belief was that Ontario would hold most of the records. So yes.
Yep.
Yeah.
In your discussions with Mr. Schachter earlier, you had discussed how Indigenous voices and perspectives are marginalized in the historical record. Do you recall that conversation?
Yes,
And certainly that might occur if one is looking mostly at primarily historical documents written by Crown officials in the English language, correct?
that's true.
And additionally, while we may have petitions from Anishinaabe parties throughout the record, those petitions would have been filtered through the understandings and the assumptions of the, I'll use the term settlers that recorded and or translated them.
Yes,
And of course, when we're looking at the historical record, we can't necessarily know precisely how the subjective beliefs or experiences or objectives of those settlers recording the petitions may have impacted on the messages that they were relaying.
that's correct.
And I guess as a broader point, we should be cautious of historical records that focus exclusively on English language documents written by Crown officials as potentially leaving out critical Indigenous perspectives. Is that fair?
I would include French language documents as well in that statement, because some of, for example, some of the petitions were originally submitted in French. So I would say French and English.
I appreciate that clarification. Thank you. But the point is whether we're looking exclusively at English language, exclusively at French language documents, some mix of both, we still need to be conscious of the fact that this record may be leaving out critical Indigenous voices.
Yes, yes.
So moving on, after 1875, you discussed how the Anishinaabe parties pressed the government for the payment of arrears.
Yes,
And you also discussed how the actual payments of arrears did not occur until, I believe you said 1903, 1904.
right.
And in response to some of these petitions or complaints from the Anishinaabe, Canadian officials responded that the government of Canada was representing their interests in the matter,
Yes,
and that Canada would not neglect their interests,
that's correct.
and telling the Anishinaabe that they didn't need to become directly involved in the matter.
Yes,
And then in the arbitrations that occurred in the 1890s, you discussed how Canada claimed to be representing the interests of the Anishinaabe.
yes,
But as far as you're aware, the Anishinaabe parties were not invited to participate in that process at all.
that's correct.
And as far as you're aware, the government of Canada did not consult with them at all about what positions it would take in the arbitrations.
Yes, I think that's correct.
And you did not see any evidence of the Anishinaabe formally requesting that the government of Canada represent them in the arbitrations.
That might be a little bit more of a nuanced answer. I think it's clear that the petitioners or the letter writers, as it may be, look to Canada to answer their questions, to, well, in some cases, to represent their interests with Ontario. But, you know, many of the petitioners also didn't understand why Ontario should be involved at all. They looked to Canada to redress their grievances. And Canada told them, there's a process, we're doing it. We are going to redress your grievances in some way.
But certainly you didn't see anything explicit in the sense of an Anishinaabe party writing to the government saying, you know, we know you're undertaking this arbitration with the provinces of Ontario and Quebec. Please represent our interests in that. Nothing of that nature.
Right. The petitions and letters we have are much more likely just to represent what their interpretations of the treaty would be, what their benefits should be, and to ask for, as I say, some redress of their grievances as to how the treaty was being implemented.
They're looking for a redress of their grievances from Canada, who they're writing to.
Yes,
They're not asking Canada to say, go to Ontario and have our grievances redressed by Ontario.
I think that's a fair statement. Yes.
And so also in the discussions between the representatives of the three governments in the arbitration process, you didn't see any evidence of any of the representatives, whether for the Dominion, Province of Ontario, or Province of Quebec, ever suggesting to one of the others that they should go and consult the Anishinaabe about one of the matters in dispute.
That's correct. I did not see any evidence of that.
And so as a result of all of this, in the arbitration process, the disputed questions, including questions about what revenues and expenditures to include, or what years had positive net revenues, those determinations were all made by the non-Indigenous parties alone. Is that fair to say?
That's correct. And, I think they also looked at this particular process that I examined in my report as being a matter between governments of settling accounts of governments.
And
So perhaps not specifically a forum to address Indigenous grievances, but just to focus on the accounting part of it as between governments.
and just to clarify in your answer, you said they saw it this way. Who's the they that you were referring to?
I think all three parties, Ontario, Quebec, and the Dominion.
Thank you very much, Dr. Jones. Those are all my questions for you today.
Thank you.
Anything in redirect?
No, Your Honor.
Thank you.
Thank you. On behalf of, I'm sure I speak for everyone in this room. And we want to express our gratitude to you for what you have brought, the contribution you have made to this history. I have said this before to all of the witnesses, and it is, it's stronger than a sentiment. I'm not sure exactly what it is, but we all appreciate the expertise that you bring to this task. We know it has been a long, long project. It has had its own costs and inconveniences, and we appreciate the respect that you have shown the process by what you have done. So thank you very much.
It has been a great privilege. Thank you.
Well. Are there any other witnesses? Okay. So this concludes the evidence portion of this case. And we'll go off the record.
Oh yay, oh yay, oh yay, the sittings of this court have now concluded. Long live the king.